Hello, everyone. Thanks for tuning into 30 Minutes with Chugh. Each week, we cover pressing topics that matter to you and your business. Just introduction of myself. My name is Navdeep Meamber. I am a senior partner and an immigration attorney with the Chugh firm based in Santa Clara, Silicon Valley, California. As you may already know, Chugh LLP is a full-service legal, accounting, and immigration firm that serves businesses across the US, India, and around the world. So what we will be covering today. Just to give an overview about employment-based green cards, in the past, I have covered downgrade of I-140 and filing 485. So we thought we would cover some of the topics related to green cards because a lot of my clients had questions. So I thought it would be helpful if we can answer some common questions we get from our clients related to downgrade I-140 and 485%. And if we have time, we'll cover some other questions. So if you have any questions, please feel free to enter your questions into the chat box at any time during the presentation, and I'll answer your questions live, permitting time. Also, just a disclaimer, I would like to provide a quick disclaimer that this event does not create an attorney-client relationship and does not constitute legal advice. It is intended for general information purposes only. All information in this webinar should be independently verified before acted upon. So now let's get started. So a lot of my clients have questions on I-140s because you know that October month has been very busy and important for some of our clients who are waiting for their green cards. So if they had a perm filed and approved, and they had I-140, which is the immigrant petition, which was filed and approved as well, and most likely under EB2 or EB3, and they were waiting for their dates to be current, right? Each month, the charts show different dates and which dates they can file their green cards on. So if we remember, if we were attending our these seminars and webinars, last in 2020 October, it was really a crazy month for most immigration because the dates really moved very fast, and a lot of our clients who were waiting for the green card dates to be current, they were like filed under EB2, and the dates moved a lot for EB3. So then they requested us to downgrade their I-140s so that they could file their I-485 adjustment of status. That's the last step to get your green card. So last year in October, we filed a lot of such cases where there were I-140s which were approved under EB2, but they could not file I-485 because of the EB2 dates, but the EB3 dates were current. So we filed another second I-140 for them, which is called downgrading under EB3. And then they were able to file their 485 based on the downgrade. So we were able to do a lot of concurrent I-140 and 485 filings. And I'm happy to inform that a lot of my clients got their green cards approved faster because of that cases we filed, and they were not even called for interview. Because of the COVID, USCIS has also been little, working differently. They were not calling for interviews, and they were also, especially towards the just a few months before October, they were trying to get the dates. They had this new date start from November. So that's a fiscal year for Department of Labor and USCIS. So they wanted to get rid of some dates before the dates changed, and a lot of green cards got approved. Having said that, a lot of my clients who filed last year in October still are waiting for the green cards to be approved too. They could not reach, the USCIS could not reach their files soon enough. So if you are one of those who have filed 485 downgrade last year and are still waiting, right? And also, a lot of my clients track their dates every month, and who have not filed 485. So we did get some requests this year that they want to file their 485. Because in October, the dates were like the USCIS said, you could use Chart B. So if you're familiar with the visa bulletin, there is a Chart A and Chart B. Chart A is the final action date chart, and Chart B is dates for filing chart, right? So we could use for October and even the new November month visa bulletin, which is already out. We could still use the chart B for that. But there's a difference here. Just before I go into the questions, I will just want to give where the current situation is, okay? When we got the chart, October visa bulletin out, and USCIS said, okay, you can choose the chart B, which is the date of filing chart. So the EB2 for the October was in July 8, 2012, okay? And EB3 was July 8, 2014. So you can see the difference, right? EB2 was like they were saying you could file your 485 if you have dates before July 8, 2012. Whereas you could do EB3 if your dates were before January 8, 2014. So some of my clients who did not want to wait, they told us like, oh yeah, let's go ahead in October and file another downgrade. And so we went ahead and filed downgrade for some of our clients in October under EB3. But now here comes interesting. So the November visa bulletin came out. It comes around mid of each month, the next month visa bulletin. So our November visa bulletin came out, and then we saw that USC said you could use the chart B. So now the interesting thing is that for November, the EB3 dates retrogressed. So, for October, the EB3 dates were Jan 2014, but in November, they're saying you can file 485 only if your dates are going to be Jan 2012. So from 2014, it went back to 2012. So now some of my clients are like, okay, the dates are retrogressing. I'm not sure we want to file EB3 downgrade anymore. So I've not filed, okay? So they want to wait. Because these clients who have EB2 approved already, right? And for the November month, the EB2 is basically saying you can do 2013, okay? Jan 2013. So these clients don't really need to downgrade. So if their dates are going to be current in if they have a date before Jan 2013, they could file their 485 directly under their EB2. So that's if you are one of those situations who were going to file downgrade in October or were waiting for November visa bulletin, and now you know what the dates are. USA still says we can use chart B, and you can see where your date stands. So accordingly, you can file under EB2, or if you think it will still help you to downgrade, which may not because November is retrogressed. And also another question, which actually now let's come back to some questions which I get. So just to be clear, even if you can file your 485 based on chart B, let's see, you have a date which is showing you are ahead in chart B, you can file it. But USCIS may not really approve your 485 till your dates, sometimes they say each month, right? They can use chart A. So if they use chart A, then they will just only work on the cases which are current as per chart A. So sometimes your 485 may just be pending there. The benefit you do get is that you can file an EAD, which is employment authorization, or you can file a 485, advance parole, which is a travel document. So now, since we talked about all this background, how the dates were, how you decide if you can do your 485 based on EB3 or EB2, let's come to some questions. So some of my clients who file I-140, they say, should I do premium processing for my I-140? What are the benefits? Yes, the benefits of filing premium processing is that I-140, you will get approval faster. So normally you will get it in within around 2 weeks if there's no RFE, okay? But if it's a downgrade case, if we are filing a downgrade I-140 along with the 485, if you are one of those in October, this month, we are still filing some downgrade cases, okay? And if you want your 485 to be filed along with your I-140, we do not recommend doing premium same time. Because there is a chance that USCIS may reject your I-140 because the second I-140 you're filing, we are using a copy of the PERM, certified PERM, okay? Because the original PERM was
Hello, yeah. So just to start, sorry, we were in the middle of doing the premium, right? So if we are doing that, if you're doing downgrade, we recommend uh, not to do as a premium. Because your IVA 485 can be rejected if there's no original perm included in it, which we don't want to take a chance. So we always recommend our clients that let's just file regular, and once you get the receipt of I-140, we can try to convert premium at that stage, okay? Because at least you will not get your 485 rejected out front in the mailroom, which has worked for us. Cases which we have filed, we get the receipt. For some of those cases, we are able to convert them premium in the first try. Some cases we have to try at least 3 or 4 times, because service center comes back saying, oh, we do not have your original perm with us. So file again after 30 days because they want to request the original perm from Department of Labor or the file for the first I-140. So that was about premium. And if you're not really downgrading your I-140, then go ahead. Then you are filing with the original perm. Then you can go ahead and file it with the premium. It will get you faster. That's the benefit. Other question we get is that, can I use the I-140 approval notice from previous employer to extend my H-1B post 6-year limit? Yes, if you had H-1B approved, if you had I-140 approved, even if you changed employer after filing your I-140, and you could use that I-140 to get your 7th year extension with your new employer, because I-140 is for the future. So the assumption is that you're going to go back to that employer at some point, right? Unless you start a new perm process with a new employer. So I-140 is for future. You could always change your employer, and you could go back to your I-140 employer because it's a future green card. But if you decide you don't want to go ahead and you still want to use that I-140, then you will have to file a perm and then file I-140 through the new employer, and you can request to recapture your date from the I-140, your priority date from the I-140. Yes, you could do that. We just have to start the whole process again. Just to here, I just want to throw that if you already had a 485 filed pending for 180 days or more, then you could just do AC-21, and you could move to a new employer based on that 485. As long as they are ready to take over your 485 process, they will have to submit supplement J. You will have to submit with their signature at one place and show that you have changed your employer and you want to take that benefit. So that's very much possible. Another question, that can I switch to consular processing after I relocate back to India and continue my green card application? So let's see situation here. You already filed 485 here, which is pending. And somehow the situation with your job or your personal or family situation requires you to move back home. Like, let's take example, India, okay? So what are you going to do with your 485, which is filed here? If you're just going traveling for 1 or 2 per month, that's a different situation, okay? You just use your advance parole to travel and come back because your home, your residence is still in the US. So once you file 485, you should be maintaining your residence in the US. You should be working here in the US as well, okay? So in intermittent travel like that is fine. But if you have a situation that you really need to move, you're not going to maintain your residence in the US, and you're not going to be working in the US, you're going to move back to home country like India, then your 485 process cannot continue because you have to be basically staying here. That's the whole 485 processes. So then you should be converting your 485, the process green card should be converted to consular process. But here's the thing, you're going to lose your 485 fees, okay? You cannot get it back. And you cannot just tell the consulates that, oh, please use my 485 fees and transfer it to the consular process. That will not happen either. So in order to happen that, you will have to have your I-140 file transferred to the National Visa Center. Okay, so for that, it's a little lengthier process. You'll have to file A24, form A24, and after A24, it takes some time to get approved. It can take months or a year. After A24, the file goes to National Visa Center, and after the file goes to National Visa Center, it will NVC, which is they'll contact you that we have received your file and we understand that you want to do consular processing. And in that case, they will ask you to submit some fees, and you have to do new forms, which can be done as a consular process. So you have to start that whole consular process from the beginning, which will add more time. Just be prepared for that. So you have to, when you take this decision that you want to do continue 485, if possible, that's the best way to do if your family situation or your employment situation allows you. But if there's not an option, you have to move back, then you will have to start the consular process, and you want to have pay new fees. Along with that, you will have to also, submit new documents. There are more documents needed at the consular process. You have to submit all those documents, and just be prepared, it's going to take more time, but it is possible. So another question, any negative impact on my AOS if I relocate back to India? This is the same thing. Yes, it's going to have a negative impact. If you're relocating back to India, then you should just think that you're going to lose your I-485 and you have to just start your consular process again. One other question which we get is that I have been waiting for my days to be current for years. What can I do to expedite the GC process and secure my US permanent residency? So if you are in that situation, your 485 is already filed, okay? And you're just waiting for the days to be current. Nothing much you can do in that case. You have to just wait for your days to be current. Nothing can be done. But if you have not filed your 485, you are one of those, some clients we have which are waiting for the dates to be current and I-140 is approved, but they can file 485 once the dates are current. So you still have to wait for the dates to be current. You can do is you can watch your monthly visa bulletin by where the dates are, but you should be prepared. It takes us time. Sometimes let's see the dates are current and our clients say, okay, I want to start my 485 process. There are a lot of documentation which are involved in 485 process, and it can take time to get those. So yes, if you are waiting for filing 485, I would recommend that you start working on the documents, which I can list some now. Important ones are your birth certificates. A lot of time we get stuck at the birth certificate stage. If you do not have a birth certificate, if you have a good birth certificate issued by the local authority, which would be municipal corporation of the jurisdiction where you were born, you're good. Even if you do not have a name, which I'll come to later, but you have a birth certificate, that's what we're going to use to submit with your 485. And if you do not have a birth certificate due to some reason or you lost it, you should work on getting that, because that can take months sometimes, and things don't work very fast with the government, right? Back home, they can take forever. Offices can be closed, or they just take forever to get the records. So please work on getting your birth certificate, whichever place you were born on. It has to be from the government authority with their seal, their signatures, and on their letterhead. Proper birth document. Have that for each family member you plan to do 485. If you have a child who's US born, you don't need to file 485 for them. Nothing needed for them. But your spouse and your children who have to file 485, make sure you have birth certificates for each of them. And if you do not have a birth certificate, then what you do? First is let's try to get that birth certificate. And if you do not have, you cannot get it, then you need to get a non-availability of birth certificate from the local authority. It cannot be from the consular. Sometimes clients ask me, oh, can I get from the US Indian consulate here in the US? Or no, USCS will not accept those. You have to get it from the government authority in your home country. It's a non-availability. Basically, the document says that we checked our records and we cannot find the birth record. So we are just issuing this certificate saying that the birth document is non-available. So we will need that to file your 485. Along with that, since you do not have a birth certificate, right? So we need to submit some additional documents. Those additional documents would be your record, which shows your date of birth, which can be your vaccination record, can be your school certificates, right, which show your date of birth. Any other records you have which show your date of birth. And we also recommend to get two affidavits from your relatives or friends, family friends who were present there at the time of your birth. Basically, they will say that, oh, I was present at the time of birth and this is the name, this is the date of birth. So I'm verifying that. Those have to be notarized affidavits, and we submit those along with evidence if we do not have a birth certificate. So, you see, there are a lot of steps involved here, so which can take time. So please have your birth certificates ready, or secondary evidence if you don't have one. Other thing would be marriage certificate. If you're filing for your spouse, you would need to submit marriage certificate to show that you're married. So that, make sure you have that. And then that has to be again from the local government. So it cannot be just from a temple, you have to get a proper certificate. So these are the documents which normally take time. Rest documents, medicals you will need to get later once your dates are current. Don't get them beforehand, because the medicals have to be submitted within 60 days of the doctor who signs it. That. And the other thing important, last thing I want to say is that now the government requires that you to have COVID vaccine. So in order to file for 85, if you have a COVID vaccine, fully vaccinated, 2 doses, good. Make sure you are saving that record to submit. And if you did not get one, this is a good time to get your COVID vaccination because we will need to submit that along with your medical record. And if due to some reason you cannot get COVID vaccine due to your religious beliefs or medical health, you will need to submit a waiver, okay? But just be prepared, you will be required to submit these documents. So this is things to be prepared, what you can do to be prepared for filing your 485. Now moving on to the next question. My son has a pending adjustment of status, that is a derivative filing on the employment-based petition from my employer. I filed my adjustment of status when the date is current under Chart B. And now my son will turn 21 years old this month, and he is on F1 status. So what will happen to his 485, right? So this is a common question we faced, and especially after last year, October, when we were filing the 485s under Chart B. So here is the bad news. Your date does not get locked under Chart B. Somehow US is not agreeing. This has been argued a lot and brought to their attention. But if you file a 485 for a child who is aging out, they are 20 years old or reaching 21, and you were able to file their 485 in October. But now, this October, they're already 21, okay, right? And if their dates did not become current under Chart A, then it's going to be hard for them because the dates only get logged when the dates become current under Chart A. So if you were in that situation, I had some clients who filed 485 under Chart B, but their dates did become current in around June, July under Chart A. They are good. Their dates logged. They had a 485. So the requirement is you have to file, right? 485, you have to start your green card process when the dates become current. So even if they filed 485 when it was Chart B and their dates become current, they didn't really have to do anything. 485 is already pending and the dates got locked. The age of the child got locked when the dates, let's see, they were 20 years and 8 months when the dates became current, okay, under Chart A. So they're good. Their date got logged. They were lucky. But if you were in that situation that, the dates did not become current for the child under Chart A, and they're already aged out, or they will be aging out before the dates current. So then at that point, when the dates become current under Chart A, you will have to do a calculation of their CSPA age. It's called Child Status Protection Act. This act, we'll need to have a different topic on that. It's a very detailed act. And normally the child's age is calculated under that act. Just to give a quick, so it has to be seen how long the I-140 was pending. And let's see, for I-480 was pending for 5 months. Then whatever is the age of the child when the days become current, at that age, they will subtract those months or years the I-140 was pending. And then they will determine what is the age of the child at that point. So if the age is still under 21, they will be covered. But if the age is over 21, their 485 will get denied at some point when they open and start working on the file. So just keep that in mind. I know we are nearing our session, so I just want to quickly wrap it up. And we were talking about the CSPA. Here is the one thing. If you did I-140 under, want to do premium, right? But your child is aging out. So it's not going to help you to file your I-140 premium, because under premium, your I-140 may get approved in 2 weeks. So you will be able to subtract only 2 weeks from your child's age. So in CSPA, it helps that the child's age, you can subtract the more time, right? So your I-140 should be pending longer. It will help it's pending 1 year, 2 year, even better. We haven't seen I-140s which are pending for 2 years, unfortunately, unless there's some issue there or RFE comes. Normally, they'll get approved within a year, around about that time. So let your I-140 be pending longer time, so that time can be subtracted from your 480 CSPA age calculation. So I think we have to quickly wrap this up. We'll have to address the questions some later time. I just want to quickly thank you for joining us. It was nice of you to join us, and if you have any other questions, you can always email those to us, at info@chugh.com. Or you can even feel free to email those to me at navdeep@chugh.com. Just to say it's NAVDEEP@chugh.com. Keep joining us on our webinars. Tune in weekly live sessions every Thursday at 11 a.m. Pacific time and 2 p.m. Eastern time. Be sure to follow us on LinkedIn, Facebook, and YouTube. You can also visit us, our website, chugh.com. And there's another website, chugh.net, which is if you have an accounting related questions, you can visit us at chugh.net. And once again, thanks so much for watching. And feel free to send us any further questions to Navdeep@chugh.com or info@chugh.com. Thank you so much.